This is Paul Turner, the Immigration Barrister at Imperium Chambers. Following up really on the guidance yesterday on false representations. Looking back, the video is quite long, quite detailed, so I thought I'd provide a short summary today, which hopefully is a little bit more digestible. In essence, following Balajigari, the Home Office has taken the general grounds of guidance and extracted false representations and created its own document, titled False Representations. It covers basically two areas: the standard false representations, which would be where someone has submitted a document and where there is obvious dishonesty, and that's covered by the case of AA Nigeria, where the Court of Appeal heard that there must be dishonesty for an individual to, it doesn't have to be conducted by the individual, but there has to be dishonesty for a refusal to stick under that. What the false representation guidance does also do is it adds, rather than just there being false representation, so a statement that's not true and the person must know that it's not true or there must be dishonesty, it adds what's called the public policy grounds to false representations. In other words, paragraph 3225 has been elevated from what was kind of a minor paragraph to getting about 8 or 9 pages of Home Office guidance as to how it should be applied. Largely as a result of the case of Balajigari. In short, what the Home Office guidance says is that where there is that not all dishonesty is sufficient to meet the paragraph 3225 threshold, it doesn't have to be criminal to meet the paragraph 3225 threshold. It's a subtle distinction, but it's a distinction nonetheless. What is also important is that the guidance recognises that the burden of establishing dishonesty is on the Secretary of State, and to do so, the Secretary of State must show that the representations were not true and that there was dishonesty. Also, and this is a key factor for individuals who perhaps made a mistake or there's something quite obvious, the guidance provides a large section on mistakes, and it talks about that you've got to the caseworker has got to consider whether or not an innocent mistake has been made, and that can be that the wrong figure has been declared, suppose the decimal point's in the wrong place. So one has to consider or not whether there is a possible innocent mistake before going on to consider whether to refuse under paragraph 3225. It gives some examples such as how easy it would be to make such an innocent mistake, how likely the applicant would be to know of the mistake, does the mistake benefit the applicant in a way, does the mistake, is it contradicted by other applications or informations, and has the innocent mistake been made on a previous application? Perhaps someone wrongly thought that they hadn't been refused a visa and had ticked the box on a number of applications. That would also point to it being an innocent mistake as opposed to some dishonesty. Crucially, and perhaps the best bit of the new guidance, is that there is a large section on procedural fairness. Now, this does flow directly from the case of Balajigari. And what it says is that if the caseworker is considering to refuse an application on dishonesty, the caseworker must issue a minded to refuse notification, and that must set out that the Secretary of State does not believe the individual, that there is an allegation, that there's some dishonesty, and it must provide the individual with the opportunity of addressing that dishonesty. It also talks about that the individuals can be given a certain period of time to respond. It suggests 14 days. However, if you can't get the evidence within 14 days, I'd make sure that your representatives actually ask for the extra time. The circumstances where the Secretary of State will issue such a minded to refuse notification is where perhaps the individual didn't know about certain information, such as the Home Office had information that the applicant didn't. That's the first thing. And secondly, where the significance of a finding of dishonesty. So if the significance of the finding of dishonesty is that the individual has to leave the United Kingdom then it is more likely that the Secretary of State must issue the minded to refuse notification. What's encouraging in this guidance is that it says that in bold letters that the applicant must be told that the Secretary of State is alleging dishonesty and give them an opportunity to respond to the allegation if the application is going to be refused on public policy grounds based on false representations. Put another way, under paragraph 3225. So that really deals with that. There is, however, discretion, and that was referred to in paragraph, I think, 34, 35 of Balajigari, which says that even if the individual has used dishonesty, because paragraph 3225 is a discretionary refusal as opposed to a mandatory refusal, such as under 3222, for example, even if, the starting point is that an application should normally be refused if there is any dishonesty, but there is, unlike the other rules, there is a discretion. Some examples of that discretion might be where the individual has given some outstanding contribution to UK society that outweighs the dishonesty. So that will be exceptional circumstances. So if you've done something, if you're a doctor perhaps, and you've been working and doing something exceptionally difficult that benefits the United Kingdom, that may justify leave being granted. The next point is human rights. Now, if the minded to refuse notification response includes a particularised human rights claim, and I would recommend that anybody that is doing such or responding includes as much information as possible. I've seen numerous applications refused where the individuals have just barely asserted Article 8 and they haven't put any details in as to the nature of the Article 8 claim. If you're going to be relying on Article 8 and you're going to be relying on children, or you're going to be relying on ill health, or you're going to be relying on length of residence, spell it out, submit evidence, put as much information in as possible, and then that could lead to the application again succeeding and discretion being exercised in your favour and ILR being granted. The last thing is the Secretary of State saves this bit to the end, which is where an individual ought to be removed, that there's no good reason for them to stay given the dishonesty, but for their human rights. And what the Secretary of State has reserved to herself is the ability to grant limited leave to remain as opposed to ILR. So there will be circumstances where the Secretary of State says, well, you've clearly been dishonest, but you've got a reasonably good Article 8 claim. I'm not going to give you ILR, but I don't think you justify it. But what I am going to do is give you some limited leave to remain. Now, that is good news, but can be bad news, because ILR, if you keep your nose clean, then within a year or so, then one can apply for nationality. If you're given discretionary leave to remain, it might only be for 2.5 years, and you might need to renew it for on at least 3 occasions before one's in a position to apply for ILR. So if you are an individual that is caught by this new guidance and you're only given 2.5 years, then you might want to study the reasons why you're being given 2.5 years and not ILR, and you might wish to speak to your lawyer in respect of that, with a view to challenging it and seeing whether you can get indefinite leave to remain. I've had a number of cases which have been allowed under Article 8 where the Secretary of State has granted 2.5 years, and I've argued that on the basis that the appeal succeeded, that the Secretary of State should have given it ILR, and the clients have been granted ILR. But each case will turn on its facts. This is an important new piece of guidance. This video is about half the length of the previous one. I just wanted to just go over the key issues in it, which essentially is that a public policy, paragraph 3225, false representations are now a standalone aspect or ground for refusal, whereas before they were subsumed in the other general grounds for refusal. And that's as a direct result of Balajigari and the need for procedural fairness. So whilst it does impose a burden on the Secretary of State, it's also incumbent on individuals, if they're given a minded to refuse notification, to provide as much information as they can. What I'd leave it with is that if you're in this sort of situation, please go and see a reputable immigration lawyer. Please go and see your own lawyer. If you're not comfortable, go and see a lawyer that you are comfortable with or that understands this. There is nothing worse than trying to present an appeal where there is no evidence been put forward, or a minded to refuse response contains no details about the person's life, family, children, health. It is vital in these circumstances to give as much information as early as possible, if not to dispel the allegation of dishonesty, then to provide justification for a grant of leave to remain. As I say, the best place to start if you're given this is by picking up the telephone and phoning your lawyer, and then getting an appointment, and then doing the best possible response you can. I hope this has been a little bit more snappy than the previous presentation, but I felt that there was a need to sort of follow it up because the last one went on for quite a while, so I went through it in some detail. Anyway, if you have an immigration problem or a member of your family has an immigration problem, please don't hesitate to contact me, Paul Turner, the immigration barrister, 0207 242 3488, or Clarks at Imperium Chambers, or at my site, the immigration barrister. I hope this has been interesting and hasn't put you to sleep. This has been Paul Turner, the immigration barrister at Imperium Chambers.